Fox News alert in just the last 30 minutes. A senior administration official confirmed to Fox News that there is still full confidence in Eric Holder at, quote, the highest levels of the White House. This comes less than 24 hours after the Justice Department offered a new defense against accusations that the Attorney General Eric Holder lied to Congress about what he knew and didn't know about potential prosecutions of members of the press for doing their job. Andrew McCarthy is from the Center for Law and Counterterrorism. He is a former DOJ prosecutor and used to put terrorists in jail for a living. Great to see you again, Andy. So what happened was these lawmakers on Capitol Hill wrote Holder a letter saying, you lied. We think you may have lied when you came before us and told us that you'd never heard of the potential prosecution of a member of the press for disclosure of materials. So Holder comes out, not himself, but an underling from the DOJ, and writes as follows, in part. Prosecutors have not pursued charges against the reporter. They're talking about James Rosen. At no time during the pendency of this matter, before or after seeking the search warrant against Rosen, have prosecutors sought approval to bring criminal charges against the reporter. Right. They basically say, even though Holder said he'd never heard of a potential prosecution, never been involved and never heard of a potential prosecution, he's exonerated because he never brought an actual prosecution.
Yeah, I've had a number of perjury cases over the years. There's two ways to deal with perjury if you're the defense lawyer. One is to prove that it wasn't perjury, that what the guy said was actually true. The other way is to look at the statement that was actually made under oath and parse the words, or see if there's a way to parse the words, right, so that you can argue literal accuracy even if there may have been an intent to deceive. Right. And I think what you're having here is this parsing of a difference between investigation and prosecution.
I feel like it's neither. I feel like it's just out of bounds. Like over here, we never actually brought anything. Forget that stuff about potential.
Yeah, but you know, it's really remarkable for them to be taking that position, because Rosen was apparently the search warrant was issued because they represented he was involved in a Espionage Act crime.
That's how they got at his records without telling him.
Right. So now they're saying, well, we never really intended to prosecute him. It's just that was a box we had to check because under the Privacy Protection Act, you have to represent that the reporter may be complicit in a crime in order to get the search warrant.
Right.
Well, the reason Congress wrote that in is because they don't want reporters to be subpoenaed unless you've already decided that what they've done is serious enough to warrant prosecution. Right. So in other words, I would have felt duty-bound back when I was an assistant U.S. attorney in Manhattan. If we had made a decision not to prosecute the reporter, and I was just checking the box because the act says that you have to check the box, I would have felt like I had to tell the judge, you know, look, we think he's complicit in the crime, but we don't have any intention of prosecuting him. We just want the information.
Right.
And
that's what this is about. They wanted the information, and they didn't want to have to notify James that they were going after it. So they labeled him as they labeled him, and now it's, what? I never heard of it. What? No, I never would have.
Another thing, though, if you've decided that you're not going to prosecute the guy, you don't write in the warrant that you're afraid he's going to become a fugitive. If he finds out
that he's a flight risk.
You know, you put in there, we're not going to prosecute him, so he's got nothing to
And in that same affidavit, they talked about how he was facing potential criminal liability. I mean, it wasn't just he's a criminal, but we'll never prosecute him. They said he faces potential criminal liability.
If the U.S. courts think the Justice Department is playing that kind of game with the courts to get a search warrant, good luck getting search warrants.
Because it's an erosion of trust between these officers of the court, the Attorney General and his staff, and the courts themselves. And you have a piece that you posted on National Review Online, and you've talked about it before, saying this is not the first time that there's been a breach of trust by Eric Holder with the public and with the congressional lawmakers before whom he is testifying. You take it all the way back to his confirmation testimony when he was confirmed as Attorney General in 2009, and you say it started even before that. The viewers, they may know who Mark Rich is, but just very, very quickly, tell us why you think he lied or misled Congress about some guy named Mark Rich.
Well, he was Mark Rich was one of the 10 most wanted fugitives. He's a big racketeer, tax cheat, etc. He was scandalously pardoned on the last day of the Clinton administration based on what I call an offline pardon process that Holder, who was Deputy Attorney General in the Clinton administration, designed for Mark Rich so that President Clinton wouldn't get input from the prosecutors in New York about what a serious offender Rich was.
So this wound up becoming a big deal because after the fact, lawmakers said, wait, how did Mark Rich get pardoned? Who was behind it? And it became a deal when Eric Holder was nominated picked, I should say, for the top spot. So here he is testifying to Congress in 2009 about what he did or did not know about Mark Rich. Listen.
That was one of the mistakes that I made. I did not really acquaint myself with his record. I knew that the matter involved, it was a tax fraud case, it was a substantial tax fraud case. I knew that he was a fugitive, but I did not know a lot of the underlying facts.
True?
When Holder was the U.S. Attorney for the District of Columbia in 1995, his office had a year-long investigation into Mark Rich's companies and actually got a settlement with one of them where the government got, I think it was $1.2 million or something. And Holder put out had a press statement. The Wall Street Journal covered it in I think 1995, 1996, where he explained that they had looked at Mark Rich for a year, looked at his companies. There was misstatements involved in getting government contracts. But
so he knew him well.
Yeah, they investigated him for a year. The stuff that they put out from their office evinced great familiarity with who he was.
Once again, on Fast and Furious, he claimed he only knew about it at a certain date, and he later had to come out and say, all right, well, I misstated that too. Now he's, backing on this testimony. You say, look, Congress has the responsibility to look into these folks who are being confirmed at the time. And when they don't, when they ignore red flags, they do so at their peril.
And not only that, but, look, Mark Rich, Fast and Furious, and now these latest hijinks, they are in and of themselves fraudulent enterprises. So why should anybody be surprised that they would mislead Congress in describing them if you get involved in them in the first place?
Andrew McCarthy, thank you, sir.